Good evening.
Good evening, sir. Welcome.
Just want to check if I can share my PPT on the screen. Can I do that?
Yes, sir. We'll just give you the permission. 1 second.
Yes, sir, you can do that, sir.
Yes, I think that's fine. Can you hear me? Yeah. Well, I can't hear you. Okay.
Yes, sir. Yes, sir.
All right.
We can hear you. Yes, sir.
Okay. That's right.
How long at this session, Ajay?
Sorry, ma'am.
How long before we start this session?
Yes, sir. We can, ma'am. We are just waiting for ma'am Lalit Bhatt, ma'am, and Honorable Justice M. Sudaresh, sir. So we'll just start in a minute, ma'am.
Ajay, ma'am is just joining.
Yes. Okay. Okay, sir. Okay, sir.
Yeah, Ajay, sir, I have joined. Honorable Justice.
Yes, sir. Yes, sir. Yes, sir.
Good evening, everybody.
Good evening, sir.
हाँ मैम, कोई बात नहीं। हाँ, अजय, अनिरुद्ध मैम ज्वाइन कर लिए हैं।
जी मैंने देखा था उनको, मैंने को होस्ट भी बनाया है। आई एम जस्ट आई थिंक मैम हैज लेफ्ट अगेन।
ओके ओके। Just joining in.
Yes. Ma'am, I joined now. Yes.
Hello, good evening, everyone. I'm sorry, I've been trying to get on to that's where the online mediation comes in and where you have a little bit of technical glitches. So this is what happened here.
No problem, ma'am. Yes, Ankita, please, you can.
Delay.
A very good evening to everyone joining us for this session today. I, Ankita Sahani, on behalf of Law Center 2 and Delhi School of Public Policy and Governance, would like to extend my heartiest greetings and welcome you all to 2021. I would now like to formally introduce today's session on innovative practices and online mediation in commercial and civil disputes. To begin, I would like to invite Professor Dr. Vageshwari Deswal ma'am, who is also a co-chair for this session, to welcome the panelists. Ma'am is an academician, a feminist, and an activist with a brilliant academic record, with being a gold medalist throughout her graduation and post-graduation. She works as a professor at the Faculty of Law, University of Delhi, and in her teaching experience of 20 years, she has authored 2 textbooks and edited 3 more. She is the editor for various leading law journals, and her blog titled Legally Speaking for the Times of India is immensely popular. In addition, she has done projects on acid attacks for the NCW, prison reforms for the NHRC, and is currently working on farmer suicides for the ICSSR. Over to you, ma'am.
Thank you, Ankita, for the kind introduction. Good afternoon, everyone, and welcome to the second International Conference on Mediation, organized by Law Center 2, Faculty of Law, DU, in association with Delhi High Court Mediation Center and Delhi School of Public Policy and Governance. Today, on day 2 of this conference, we have planned this session on innovative practices and online mediation in commercial and civil disputes, for which we have 3 eminent dignitaries who have kindly consented to share their views on their area of expertise with us. It is my proud privilege to introduce them to you. First of all, I would like to extend a warm welcome to our chief guest for this session, Honorable Mr. Justice M.M. Sundaresh. Justice Sundaresh holds a BA degree from Loyola College, Chennai, and a BA degree from Madras Law College. He was enrolled as an advocate in the year 1985 and has worked as government advocate between 1991 to 1996. He has extensive practice in civil appellate, criminal, and writ jurisdiction in the Honorable High Court. He was appointed as a member of the Monitoring Committee to oversee the establishment of reverse osmosis system to the dying units of Tirupur, Karur, and Erode district by the Honorable High Court. He was also appointed as an additional judge of Madras High Court on 31st March 2009 and appointed as a permanent judge of Madras High Court on 29th March 2011. He has also graciously consented to chair this session. I will be co-chairing this session alongside him. Sir, thanks a lot for agreeing to spare your time and spending this time with us today. We welcome you to this conference.
It's fine.
Next, we have with us Senior Advocate Sudhanshu Batra. We welcome you, sir. Advocate Batra is a practicing senior advocate at the Supreme Court of India, the Delhi High Court, and also various tribunals. He is a trained mediator. He has been an organizing secretary of the Delhi High Court Mediation and Conciliation Center, Samadhan, for 6.5 years. Advocate Batra has been appointed as an observer by the Mediation and Conciliation Project Committee of the Supreme Court of India for observing the training of trained mediators. Mr. Batra is a member of the Overseeing Committee of the Delhi High Court Mediation and Conciliation Center and is empaneled as a mediator with Samadhan, Singapore International Mediation Center, and is also a former Vice President of Madhyam, Council for Conflict Resolution. In addition, he is also empaneled as a mediator with a private mediation center with Camp Bangalore. Thank you for agreeing to grace the occasion and welcome, sir.
Thank you.
It is also a pleasure to welcome Ms. Lalit Mohini Bhatt. Madam is a practicing advocate with 29 years standing and is also the senior founding partner of the law firm Law Links. She is a trained mediator and has been enrolled with the Delhi High Court Mediation Center Samadhan since 2006. She has conducted mediation sessions in over 300 cases. She is also enrolled as a senior mediator with the Bombay Chambers of Commerce and Industry and is also an advisory member of the Justice Committee of Punjab and Haryana Chambers of Commerce and Industry. Madam was accredited as a mediator by the Chartered Institute of Arbitration London in 2019, Prime Disputes London in 2020, and Asia Pacific Center for Arbitration and Mediation in 2020. We are extremely lucky to have such eminent speakers with us today. Now over to you, Ankita.
Thank you so much, ma'am. With this, I invite Mr. Sudhanshu Batra, sir, who is also a guest of honor for this session, to share his wide and rich experience with us. So,
Thank you so much for the very kind introduction. Honorable Justice M.M. Sundaresh, Dr. Rajeshwari Deswal, my dear friend and colleague, Ms. Lalit Mohini Bhatt, and of course, the dignitaries present today, as well as my dear friends. It's indeed a great pleasure to address the young minds, especially on the topic such as innovative practices and online mediation. Innovation in creativity is found most in the young minds, and that is why this topic becomes very interesting. In fact, today's topic reminds me of the year 2006, when the Delhi High Court was setting up its first court-annexed mediation center. I confess that the reaction of most lawyers was very negative. They could not even imagine that anything different from a traditional adjudicatory system of dispensation of justice would be acceptable, workable, or profitable. They felt threatened that the very source of earning their income is going to undergo a big change, and therefore they preferred to call ADR an alarming drop in revenue. Change of any kind is resisted. Creative changes, innovative changes. The process of introducing new ideas of method is an innovation in itself. But very soon, this method of dispensation of justice through mediation started getting acceptance both by the litigants, the lawyers, and the judges. And today, it is much appreciated throughout the country. It dawned upon everybody that issues relating to conflict between the parties that can never be addressed by the courts can be most appropriately dealt with through this non-adjudicatory system of dispensation of justice. Relationship issues, the power to make your own decision, the empowerment of the parties themselves, issues beyond the list before the courts, and many more could be addressed, understood in the right perspective, and resolved by the disputants themselves and for themselves. It is this forum where the disputants get an opportunity to write their own judgments rather than depend upon a third party to write a judgment for them. A forum which encourages disputants to assess and analyze their present and future interests, generate options for a solution, and thus use the most creative and innovative method of dispensation of justice. Once the mediation movement caught up, more and more litigants started opting for it while their matters were pending in the court. Gradually, even pre-litigation mediation started picking up. Today, amongst the lawyers, there is a huge waiting list of lawyers waiting to be trained as mediators. And I can assure you that 60% of the matters that are referred to the mediation center of the Delhi High Court have been successfully and amicably settled by the party with the assistance of the mediator. Now, this was an innovative change in the adjudicatory system, from an adjudicatory system to a non-adjudicatory system. It found place in Section 89 of the Code of Civil Procedure. Now, with the pandemic coming and hitting the lives of millions of people across the globe, mediation too suffered a setback. But soon, it was on its wheels through this electronic platform. Many conflicts relating to family disputes, matrimonial disputes, commercial disputes have been successfully settled through this innovative method of online mediation. I would like to share a presentation on online mediation with you. I hope you can see it. Is it visible?
Not yet, sir.
No, it's not visible. Maybe you can share screen probably.
I did do that. I'll do that again. Just a moment. Is it now visible?
No, sir.
I think there is a bit of an issue, but I don't know why it's not getting shared. But anyway, I will.
Sir, you can share, if you would like to share the PPT with us, we can share from here.
All right, I'll just.
Yeah. You can just send it to.
Yes,
yeah.
yes. That would be nice.
Even you can WhatsApp us, not an issue.
Just a moment.
So you can send me, sir. I'll forward to Ajay Sonowanes.
All right, all right. I've sent it. I've sent it. Have you received it?
No, sir. I have not received, sir.
It's been delivered.
So you can forward to Ankita also. I think if
Yes,
you
sir.
have.
Yes, sir. So you may forward it on WhatsApp.
I've given it on mail. I've sent it on mail.
Okay, sir.
I've sent to both on mail.
Okay, sir. Yeah, sir. I've received it, sir.
Okay, thank you.
Ajay?
Yes, sir. Please send it, sir.
मैंने भेज दिया. I have sent it.
Yes.
Let me start with a quote by the time they show it. If lawyers are not leaders in marshalling cooperation and designing mechanisms that allow it to flourish, they will not be at the center of most creative social experiments of our time. This was said by Derek Bock, a very famous mediator and an educator and a lawyer. And it is the lawyers who are at the center stage of coming up with creative and innovative solutions to their problems. So today's pandemic in India has made almost all mediation centers shift from the physical mediation to online mediation. Now, this topic really deals with reference to commercial mediation and civil disputes. To understand what is commercial mediation, it would be defined as mediation which deals with conflicts that give rise to commercial disputes. Are you able to share the slides?
Yes, sir. Just a second, sir. Yes, sir. Yes, sir.
Yes, the next slide. Next slide. So if you see, what is commercial mediation? Commercial mediation can be defined as mediation which deals with conflicts that give rise to commercial disputes. And what is commercial disputes? Commercial disputes, next please, is broad and includes contractual disputes, conflicts between landlords and tenants, disagreements between business partners, IPR disputes, builder and home buyer disputes, and many more. So you see, commercial disputes is a very wide range where all sorts of disputes, even family disputes, where two families have joined together to do business and two brothers have joined together. Later on, their families expand. When their families expand, there are some differences, that the conflicts between the parties that result in litigation connected with their businesses. So there are a lot of disputes which are sort of commercial disputes. Next para. But the essence, that the most important aspect for any commercial organization is to resolve these disputes, because time is the essence in any commercial dispute. It is imperative for organizations to be able to get more business than spend time and energy on litigation. Time and sustenance of relationships are valuable in commerce. So you see, when the matter goes to court in commercial mediation, in commercial disputes, it takes a long time for the disputes to get resolved. Here, time for the parties is very, very essential. So a lot of them have now decided to opt for online mediation because they feel there are a lot of advantages, which I'll just come and explain to you as to what are the advantages of online mediation in commercial disputes. But because one, time is the most important aspect in commercial disputes, then sustenance of relationships. In a family dispute, when there is dispute between the parties, then the relationship between the parents and the children, between the siblings, between their cousins, and so on. In matrimonial disputes, you will see the relationship between the husband and the wife. Even in commercial dispute, there is a business relationship between the parties. Parties actually don't want to sever a relationship with the parties because this is not in the best interest of their business. So we have seen where parties tend to resolve their disputes, they come up with such innovative and creative options that they, despite, after not only resolving their disputes, they continue to retain their healthy relationship with which they started their business. So commercial agreements have to follow a more structured process for provisioning and managing those disputes. Because once the parties continue to settle their disputes and continue to do business, that agreement must be properly structured, and provisioning should be made about, in case there is a future difference between the parties, how do you resolve it without resort to litigation and so on. So the commercial agreements are a very important aspect in a commercial dispute. Next slide, next. Online mediation is a process by which parties settle their disputes online without being physically present at the location. Online mediation requires a modified approach and training to adapt the skills compatible with an incorporeal digital forum. Now you see, there is a lot of advantage of online dispute. One is the locational advantage. One party is in Bangalore, one is in Delhi. And the advantage is that they don't need to travel to meet each other and have physical sessions. They can conduct mediation through the online process. But the process that the mediator has to carry forward needs to be adopted or modified slightly. And how do we do that? We'll come to that as we progress. Next slide, please. The question that often comes, it's been more than 1 year of the pandemic. Have mediators handled the shift from physical mediation to online mediations during the pandemic? That question comes to the minds of everybody. How does in-person mediation differ from online mediation? And what have mediators done to capitalize on those differences to excel in virtual mediation? And what is the future of online dispute resolution, ODR, and virtual mediation? Now, ODR, mediation is only one part of ODR. Online dispute resolution can be through arbitration. It can be through conciliation. It can be through negotiation. It can be through any form. So mediation, virtual mediation, is one of the ODRs, that is online mediation, similar to ADR, which is an alternate dispute resolution forum. Next slide, please. So the first question is, have mediators handled the shift from physical mediation to online mediations during the pandemic? The answer is yes. The mediators have been able to handle the shift from physical mediation to online mediation very successfully. In fact, making it as a necessity, mediators have shown the efficiency and the effectiveness of this form of mediation. And how did they do that? We'll go again, talk about the advantages and what is the effect. Next slide, please. How does in-person mediation differ from online mediation? And what have mediators done to capitalize on those differences to excel in virtual mediation? Now, physical meetings are as different from e-meetings like any other meeting. For mediators, the situation might be a little more challenging because the adaptation of change by the parties, you see, here there are all sorts of parties that come before the mediator. Now, how I said you need to modify, here is the question. Here is the answer to that question. You see, in physical mediation, when the parties are physically seen sitting next to you, you can very closely watch their body language. You can make eye contact with them very easily when they're physically present. Now, when you're on a virtual screen, of course, you can still watch the body language. It's not that you can't. You can still attract their attention, but you need to be a little more vocal. So one, the listening aspect of mediation, which is the most important part of communication, has to be kept that in mind, and yet you have to be vocal and connect with the parties through this virtual forum. Now, parties often do not know how to handle technology. There is a lot of difficulty that we face sometimes, but then you have to show a lot of patience. You have to assist the parties in helping them how to understand, how to adapt the technology so that they are also able to communicate what they want to communicate. So the challenge for a mediator, when in online meetings, when we have, let's say, corporate meetings or academicians when they meet, all of them are much more familiar with technology, but disputants may not necessarily be, because disputants may come from varied sections of the society. So they may not be very comfortable. Sometimes some of them will operate only from their telephones, from their mobile phones, while the others will use laptops or iPads. So you have to adjust yourself. So that challenge for the mediator has to be much more. However, with the skill that the mediators have, they can very well adapt. And we've seen in the past over 1 year that the mediators have shown exemplary adjustment and have made the parties as comfortable as possible. Next slide, please. Now, with everybody talks about the new normal, that now we're going to enter into a new normal. That is, this is the new normal, that we are all going to be working from homes. We are not going to go out so often. Yes, that is true, at least for a certain extent. But I don't think this is a permanent feature. These things are also passing phases, and we will certainly get over them. And once again, the old normal shall be returned. But even when the old normal returns, the advantages that people have seen of online mediation, they would like to adopt that method even then. So ODR and virtual mediation certainly has a very, very bright future. And what we see that people are we have done mediation where parties are sitting in London, parties are sitting in Sri Lanka, and parties are sitting in Delhi, and 3 different parties. There are multi-party mediations, and they've become so comfortable in discussing mediation that for hours together, our sessions go on. And nobody feels as if, that we are missing the physical presence. And this is more so in commercial mediation. And I must also confess that when it comes to matrimonial mediation, where emotions are very high, there perhaps physical mediation definitely has an advantage over the online mediation. Now, the other interesting, please, the same slide. The other interesting aspect of online mediation, and we see future of it, is that when we studied law colleges never had subjects like ADR or ODR. Today, law colleges have introduced, most of the law colleges have introduced this subject. But the only tweaking that needs to be done is that the curriculum for all these law colleges and all over the country must be similar, if not identical. We must all, this is a great opportunity for academicians to frame a curriculum which is consistent for all colleges. For instance, you see, mediation is not a codified law. Not being a codified law, this requires more sort of concentration, focus on the curriculum. Because if you're teaching, let's say, Contract Act or minor acts, these statutes are there. The interpretation of the statute is there. We know how to interpret a statute. There is administrative law, there's interpretation of statute, there's constitution law, there is criminal law. All these statutes are there, and the teaching becomes easier because you have the codified law in front of you and the interpretation of those provisions by the various courts. But here, since there is mediation is never going to be codified in that extent. There may be a mediation act, but the moment mediation becomes codified, it will lose the very essence of mediation, because it is supposed to be a flexible process. It is supposed to be a process that gives parties to think out of the box, to arrive at solutions which are different but yet enforceable in law. So we cannot possibly have a rigid statute which governs mediation. So therefore, focus on consistency in the curriculum by all the law schools must be adopted. Then the other aspect is that we must have trained mediators. See, that is something which is very important. So the future is very bright, provided these aspects are taken into consideration. We don't only require trained mediators, but we also require good trainers to train the mediators. And that also, a lot of academicians, lawyers, and judges feel that we require more specialized people who can train lawyers as mediators, or as law students as mediators. Next slide, please. Now, online mediation, commercial mediation, you can very see it's online plus commercial disputes is online commercial mediation. So mediation sessions are conducted through online medium by a neutral third party. Mediation skills and technological skills become equally important for a successful online commercial mediation. Now, if you see mediation skills that are taught in schools or in training programs, those have to remain intact. Apart from that, you must also have technological skills, because technology is the medium of communication. The physical communication mode has disappeared and technology has stepped in. So that knowledge of technology is a must for online commercial mediation, or any form of mediation for that matter. Next slide, please. Now, features of online mediation, as I said, it remains the same. Mediation continues to be a voluntary process. You cannot force the parties to settle. You cannot advise them as mediator. You cannot decide for them. They must voluntarily come forward to find a solution for themselves. And the moment you're able to convince them or persuade them to take voluntary decisions, 50% of your job is done as a skilled mediator. Of course, in online mediation, the only additional aspect of the features of mediation is that it uses technology. And in neutral third party has to be there for mediation. It has to use specialized communication skills and negotiation techniques to assist disputants to resolve their disputes. Next slide. Now, what are the essentials that are required for online commercial mediation? One is you must have a safe platform to conduct mediation. Now, why do I say safe platform to conduct mediation? See, one of the most essential aspects of mediation is it is a confidential process. It's a process where the mediator develops trust with the parties, where the mediator creates trust with the parties to such an extent that he does not, the parties never go to, they never think that the mediator is biased or he has any prejudices. And therefore, to create that trust, confidentiality must be maintained. And to maintain confidentiality, we must have a safe electronic platform. Now, this is a very risky thing in online mediation. When we started online mediation, the first thing that came to our minds was, how do we stop parties from recording? How do we stop the parties from taking photographs, or from making taking screenshots, or to record the whatever is communicated, because the entire process is supposed to be confidential. So therefore, what we devised is that in the beginning, when the parties log on to any system, there is a window that comes which gives a confidentiality clause. Of course, every court is now accepted, and they accept the fact that anything said or exchanged in mediation cannot be used in evidence in the court. But yet, if parties would want to abuse it, they can always say that this has not been procured through the mediation process. This information or this document has not been procured, and they can misuse it. So we make this, we create this window in the beginning when the parties join. If you recall, there is a button which says, I agree to the terms and conditions. One of the terms is that they will not do any recording. They will keep everything in complete confidence. They will not share this information with anybody, and whatever is being discussed will remain within the framework of whoever the participants are. A strategy to restore. Now, in commercial mediation, another essential aspect is that the mediator must have an additional skill and a strategy to restore the commercial relationship which has become soured, and because of which the parties are in litigation or disputes have arisen between the parties. And the agreement that the parties are entering into has to be honored. It has to be enforced in true letter and spirit. You see, any agreement which is done in haste or out of pressure will never be enforced, and ultimately that too will go into further litigation. And in order to stop that, that strategy has to be made by the mediator, that you must concentrate on restoring the commercial relationship between the parties and to honor the settlement agreement in its right perspective. And of course, the most important part is that the parties have to decide. It is not the mediator who decides. So the parties must also get that feeling that the decision is theirs. And for that, the question of empowerment of the party comes in. And that is another very crucial aspect, which in online mediation, the mediator has to very skillfully and subtly convey to the parties that they are the ones who are empowered to take the decision. And whatever decision and the consequences of that decision rests solely on them. And it should not result in a blame game. Next slide, please. Now, what are the advantages of online mediation? We all know there are many, many advantages, but broadly, we can say one is locational advantage. It saves costs. It saves time. There are new opportunities and accessibility. The process and communication improvements are there. So we'll come one by one to each of the advantages. One is, next slide, please, locational advantage. The first and the most important benefit of online mediation is holding mediation sessions from separate and remote locations. You know, it's very interesting now. For this, of course, you need a good internet. You need good connections. And this, I think, as far as India is concerned, we are making huge progress. And in the coming years, that is why we say there is huge scope for online mediation, because in the coming years, you will see that the connectivity will improve tremendously. In the US, I was attending one of the webinars where they said that almost all courts in the US, at least 95% of the courts, have no problem as far as connectivity is concerned. But this, of course, in India is not correct, is not true, and this is going to take some time. But when it happens, even from remote places, from the hills, right to the beach, people are there, they can get connected, and online mediation can be very successful. So locational advantage, you do not travel. You do not need to book hotels. You do not need to worry about catching your flights or going back by train or whatever mode you've come through. So all these advantages are there that you immediately get connected. You save so much of time. You're sitting at one location. And today, for instance, there was a session. I didn't need to get ready and shift to my car and reach the destination of the venue. Today, we've created a venue in our own rooms, in our own houses. Every household is a venue in itself. And that's the beauty of online mediation. Next slide, please. As I said, it saves costs. Now, costs, one, online mediation, the parties resolve the matters quickly because there are short adjournments between sessions, because there is a possibility to adjust. You're not traveling, you have more time on your hand. It saves costs in terms of your travel, in terms of your accommodation, in terms of working on, of course, the litigation cost. It saves so much if there's a successful online mediation. So cost saving is one of the most important benefit of online mediation. Next comes time. Next slide, please. It saves time. Mediators and participants alike are able to save time by meeting remotely. Movement between rooms during caucus is instantaneous when virtual. Yes, this aspect I'd like to tell you. We have separate meetings. I'm sure that you're all familiar with how the mediation is structured and what is the structure of mediation. We have joint sessions. We have separate sessions. Now, when we have separate sessions, we break the joint session and we request the parties to move into the other room. This itself, the process takes about 5-10 minutes. And then once one party private session is over, then you call the other party, and the other party is then called upon. So there's about 15-20 minutes, half an hour straight away you waste on all those things. Now that instantly, because this technology gives you the option of breaking up rooms or shifting parties to the lobby. For instance, we do that very often now. Now there is a joint session, and during the process of the joint session, it is felt by the mediator, it's time to now break up and have separate session. And we just, as a host, we just click and we shift the parties from the main meeting room to the lobby. So the party is not disconnected, but the party can't hear or see each other while the conversation is going on. If the mediator is having a separate conversation with the parties, you're having a separate conversation. The other party does not know what conversation is being had. So that confidentiality can also be maintained. And this happens in the split of seconds. Then immediate switching of rooms saves time, increments of time, and helps create a more streamlined and efficient mediation. Next slide, please. New opportunities and accessibilities. Remote aspect of online mediation opens the doors to new possibilities in the mediation field by potentially expanding individual mediators' practices. Now, I'll be very honest with you. In the court, when we are working, our courts start at about 10:30 in the morning, and they wind up by about 4:30. Now, by the time you come back to your office, if you have a chamber in the court premises, excellent. Otherwise, you have to travel to your office premises. It takes about half an hour, 45 minutes to reach. Now, you have conferences, you have meetings with the clients for the following day or for some new clients. And then, where is the time where you can devote for mediation? Because mediation is something you're very passionate about, and that's exactly why you're opted to do mediation. Now, mediation sessions sometimes take hours together. Now, you see, when there's online mediation, I have, for instance, wound up my online hearings in the court by 4:30, and I have done 2 to 3 mediations in a day, while actually physically I could not do more than 1. Because I had to attend to my court hearings also. I had to prepare for the matters for the following day. So here you get an opportunity to do many more mediations, and you can do it on Sundays sitting at home. And I'm sure that a lot of people have, of course, nobody wants to spend Sunday working, but if you're passionate about it, mediation is one thing which we've seen. When you get involved with it, you eat, you drink, you sleep, only mediation. Mediation is very addictive because you'd get so much of satisfaction to the mediators when the parties actually settle their disputes. And this gives me time to quote Barry Ross. He's also a very veteran mediator and international mediator. He says, as a result of COVID-19 and the expansion of virtual meeting platforms, previous constraints on travel and physical closeness have been dissolved. The former arbitrary borders and limited paradigms of human interaction no longer exist. These new circumstances have ushered in an era of remote meeting with mediations being conducted from anywhere in the world. But with new paradigms comes a demand for new skills to be developed. So while the means of human interface has changed, the quality of communication must remain as effective and as clear as in any in-person mediation. So that should be the mantra of online mediation, that the quality of communication must be effective, it must be clear, just as in in-person mediation. So the language, the words that you use, you have to be accurate. You have to use the language that is the mediation lingo. We call it, it's slightly different from the legal lingo that we use, because legal is adversarial. As a litigator, you use adversarial language. The language is also adversarial. We use vexatious, malafide. But here you have to use such words which we call the mediation lingo. And that effectiveness, you can actually hone your skills while you're doing online mediation, because the chance of speaking orally through mediation process is much more than opportunity. Next slide, please. Now the process and communication improvement is there. Communication process changes with the use of online mediation as the main medium of communication. It improves the communication process by giving more control to the mediator and by increasing the awareness of other participants' reactions as well as their own. Mediators have found that virtual format provides mediators with ability to mute or separate people and watch themselves too. Now you see, in online mediation, you have control on who you can mute, who you can't mute. And the best is you're also watching yourself on the screen. So your body language, how you sit, what are your gestures, all things become absolutely visible to you. So that's when you can correct yourself as well. And you can use that process of communication to the best use through online mediation. Next slide, please. Now, the effectiveness of online mechanism in resolving commercial dispute. Commercial disputes are almost always monetary. So there are relationships involved. I'm not saying that there are no relationship involved. There are a huge amount of relationships, but emotions are not so much. Of course, in some mediations, even commercial mediations, emotions are too much because somebody has to pay the money and that person doesn't have the money to pay. And there is so much of tension in the house. So there are a lot of emotions that are coming up. But yes, main thing in commercial disputes is monetary in nature, which can destabilize the market if they are stretched for too long. So the effectiveness of online mediation is that we can reduce the time. We can reduce it much more than in-person mediation. Parties from different states and different countries prefer having e-meetings than physical meets. Parties physically being in their comfort zone are more independent in the process. So, and hence tend to take quick decisions. You see, when you're sitting in your room, you're in total control in the environment. So your confidence level and your thought process comes naturally rather than go to a different environment and create that kind of comfort in that environment. So here online mediation gives that advantage to the parties. They are sitting there, they're in a comfortable zone, and they can, with confidence, come up with some solutions. Some solutions that ultimately, because they know what is in their best interest, what is their interest as on today, and what is their interest for the future. Next slide, please. So the practices to be followed in online mediation, in online commercial mediations, one is effective communication. The other is knowledge of technology. Then there must be connectivity and there must be confidentiality. The four principles you must keep in line for an effective online practice online mediation practice, especially commercial. One is effective communication. You must have knowledge of technology. In fact, not only how to use technology, but how technology can use, how the entire process works. Could you give me the next slide? I'll show you this process. But effective, next slide, please. So effective communication, I'll quickly run through because I think we are running out of time. It's verbal communication, you're all very familiar with. Non-verbal communication, body language is very, very important. So even in online mediation, you must be careful the way you sit, the way you're dressed, the way you're looking at the parties, your silence in the process. All those non-verbal communications are important. The body language is important, and active listening skills. I said 97% of the communication, they say, is non-verbal communication. And that is, a lot of it is through active listening. The most effective communication skill will be to listen to the parties because they want to be heard. They don't get an opportunity in the court. And here you give them an opportunity. And through online mediation, they will have all the time to speak, to say what they want to. Next slide, please. So think before you speak. The words that you use, that's very important. Speak with confidence. You must be clear and concise. Use voice modulation because it is very, very effective. Next slide, please. Types of nonverbal communication, as I said, is physical appearance, facial expressions, your gestural communication, the touch communication, and the space communication. Next slide. The physical demonstrations of attentiveness is summarized in the acronym SOUL. Symmetry, you must sit with open arms. You must be leaning forward when you understand, when you agree with something, you must lean. For instance, you give an acknowledgement that the other person has been understood, and your eye contact. So this acronym, you can remember, SOUL, it's symmetry, open, leaning, and eye contact. Next slide, please. Then active listening skills, I said, is the most important. It shows people that they've been heard. It gives them satisfaction. You've also understood. You can also focus on the right issues. You can summarize for them. You can shift the unnecessary, irrelevant facts and focus on the real issue or controversies between the parties. Next, please. Knowledge of technology. Thorough understanding of the way in which technology and software work is essential in online mediation. Know how to work the software and how the software works. So one is you know how to work the software and how the software itself works. A clear understanding of what parties are actually seeing, not what they should be seeing. Next slide, please. It is extremely important to have a good internet connection. Trying to work through a poor connection will make the parties lose faith and confidence. We've seen in actual mediation, when there is a connectivity issue, the parties disappears. Even the interest of the mediator goes away because you are straining yourself. It becomes a hell of a problem. So when there is a connectivity issue, mediation sessions create a problem. And this is actually a practical problem that we are facing. But nevertheless, this will soon be overcome because things are improving. Now you have these fiber connections. So fiber connections are much faster. You can opt for a high-speed network. So the connectivity becomes important, but it's also important that the other side or the parties also have that kind of a system. And I'm sure that as things are progressing and with this pandemic, new things have been learned by the government and all over, and these things will obviously start catching up and it will improve. The platform of mediation should be chosen according to the comfort of all the parties. So there are various kinds of platforms. One is Zoom. The other is Cisco. Then there is a Geo platform. There are so many other platforms. So let's try and use those platforms where the parties are more comfortable with, because ultimately the party is new to use. You have to adapt yourself. You have to learn those platforms, but the parties also need to understand and adapt themselves to that platform. Next, please. Confidentiality, as I said, extremely important. Gadgets working on the voice command should be put on off so that the proceedings cannot be recorded. Mediation should be locked so that no unauthorized access is given to the virtual mediation room. Before entering mediation proceedings, parties should be made to sign an agreement to maintain confidentiality of proceedings. The agreement should also mention that the consequences of such breach in the agreement is contemptuous or some kind of a deterrent, so the parties are confident that they must not breach that confidentiality. That is in sum. I had to run through it. It's been almost an hour, and I think we have other speakers as well. Thank you for a patient hearing, and if any question is you'd like to ask, you're most welcome.
So we may take the questions towards the end of the session.
All
right. I would like to thank you for the very comprehensive presentation and taking us through the very intricate and pertinent details of online mediation. I would now like to invite a second guest of honor, Ms. Lalit Mohini Bhatt ma'am, to please share her expertise and address the gathering.
Thank you very much. It is always a challenge to speak after a brilliant lecture, but I'll still try my best. Honorable Justice Sundaresh, Madam Deshwal, Dr. Deshwal.
Madam, I think you're being very kind, but I must tell you that you're equally brilliant. I mean, if you call me brilliant.
No, Mr. Batra. You're being very... Dr. Deshwal, Mr. Sudhanshu Batra, students, dignitaries, and the guests. It's a pleasure to have been invited to speak at the second International Conference on Mediation this year. Mediation is a form of an alternate dispute resolution process of resolving disputes with the help of a third neutral person who assists the parties in the disputes to reach a negotiated resolution. This process is voluntary, party-centered, and a structured form of negotiation. A variety of disputes are amenable to mediation, which Mr. Batra has also mentioned, including commercial, contractual, business, corporate, employment, intellectual property, family disputes, etc. Mediation has the ability to enhance access to justice while doing so expeditiously and in a cost-effective manner. It was reported recently that the ratio of judges in India is abysmally low to 12-13 per 1 million persons. Judicial dockets have been historically overwhelmed, and the COVID-19 crisis has only served to worsen the burden on the judiciary. With courts only being able to hear urgent matters in the light of an unprecedented public health crisis, long pending matters have no immediate redressal. And the nature of the crisis has led to even more litigation that courts are unable to grapple with. The situation is now only going to worsen since thousands of disputes directly attributable to COVID-19 induced lockdown are waiting to enter the system. Delay on account of lack of access to courts will have effects not just on parties but on economy as a whole. Mediation has a crucial, at this stage, mediation has a crucial role to play in access to justice and ensuring that disputes are resolved in a faster, more efficient ways. Mediation also has a special ability to turn antagonistic relations into collaborative ones. Unlike court proceedings or even arbitration, which may be enhanced by the physical presence of parties, mediation could actually be more efficient in the virtual mode. Other than brief sessions with the parties together at the outset, the mediation procedure involves the mediator meeting one-on-one with each party as he or she attempts to convey positions and assist in the realistic recognition of the strengths and weaknesses of a party's claim or defense. It is actually more efficient for this procedure to occur via teleconference or opposed to conference from hopping from one room to another. And Mr. Batra has also mentioned that it is more relatable. You can switch on, switch off, mute, unmute, all those things can be done while you are an online mediation. The pandemic has perhaps forged a recognition that mediation is very well suited to occur remotely and that it can be far more effective way to resolve disputes in a way that both parties may gain something from. Increased and more efficient mediation processes occurring remotely will result in higher number of amicable dispute resolutions, relieving overburdened judicial dockets. Likewise, disputes destined for arbitration by virtue of a dispute resolution clause, be it institutional or ad hoc, may also be more effectively resolved in mediation. At its core, mediation is a confidential conversation between the mediator and the parties. Already discussed in detail by Mr. Batra, it focuses on uncovering interest and eliciting suggestions from the parties themselves for practical solutions to resolve the dispute. Opposite to adversarial litigation that happens in the open court, mediation is a confidential, more flexible process that might be better suited to be conducted online. Over the past few years, mediation has gained rapid ground and become more accepted as an efficient mechanism. The courts backed by legislation have also been enthusiastic about referring disputes to mediation. The great advantage of online mediation, given the context of the pandemic, and mostly in this situation where we are in today, which is really going out of control, is that it is convenient, cost-effective, and efficient use of time. Parties do not have to travel or wait long hours. They do not have to make multiple visits to court or even the mediation center. In the online process, participants may even feel safer. This is a significant advantage in family disputes, for example, where the party may be able to better express their claims and difficulties from the comfort of a familiar and safe space, which is their home. This is a great benefit in cases where face-to-face confrontation may heighten the conflict. All these advantages of online mediation are of course contingent on access to internet and mechanism to ensure that confidentiality is not compromised. As ever, questions of access to justice and non-exclusion of those who are underprivileged must be at the heart of a push towards online dispute resolution. The question today is how well can we adopt technology to enhance access to justice and strengthen rule of law? We should use technology to promote a sense of inclusive justice. Technology employed for online dispute resolution and specifically mediation should have easily accessible user controls. This is because mediation, unlike arbitration, is not confined to high-value disputes. Several persons with smaller dispute without financial resources or family dispute have much to gain from mediating their disputes, but may not necessarily be technologically literate. Technology should promote user confidence in the process and ensure confidentiality as best as is possible. Mechanism to incentivize online mediation would also be helpful. Resolving COVID-related disputes should be of importance, and ODR can be employed for those purposes. Eventually, ODR can be employed for other cases, including personal disputes. Two crucial things that are necessary is to identify what kind of cases can be resolved at the pre-litigation stage and to identify the incentives and disincentives which can be provided to boost the pre-litigation mediation. There are three categories here to be mindful of. First, kinds of cases where pre-litigation mediation is imperative. It is not possible to go to courts for problem arising out of transactions over e-commerce companies. In-house mechanism create trust in the consumers that grievances will be settled, particularly through mediation, and this is even more effective and economical in the online platform form. Access to remedies is very fast and sincere, and since the nature of the dispute is such that there may be multiple consumer issues on the same product or type of product, solutions through ODR are easily crafted. Bulk cases such as check bounce cases are suitable for online dispute resolution and pre-litigation mediation. Insolvency disputes, commercial and property disputes, and family disputes can also be resolved through pre-litigation mediation. Consumers and private parties bringing causes of action before court should be made more aware of the efficacy of pre-litigation mediation and, in the context of the pandemic, the efficiency of online mediation. The pandemic presents a unique opportunity where parties are more open to and willing to mediate their disputes, rather than enter litigation that involves exposure to infection, higher costs, uncertainty in when courts may hear the matter substantively. There must also be greater awareness within the legal community itself about how this is an opportunity for them to grow too, and not see this as a threat to practitioners. The way ahead in pandemic lies in the transformation of the dispute resolution ecosystem to adapt to the changing demands of justice by using technology. The judiciary has openly embraced technology as a means to deliver inclusive justice. Even during the nationwide lockdown, courts were kept accessible to albeit to a limited extent, though e-filing and virtual hearings, and now it is steadily moving towards adopting a futuristic vision of virtual courts, where certain categories of cases will be resolved entirely online. The judiciary has mostly been unwavering in its support for ADR. In the case of Salem Advocate Bar Association too, the Supreme Court took a strong pro-mediation stance. This led to framing of models, rules, and establishment of court annexed mediation centers, bringing a mediation into formal framework for the first time. Further, the Supreme Court, in its decision in the case of Afcons Infrastructure Limited versus Cheran Constructions, specifically identified the following case types as being suitable for ADR. All cases relating to trade, commerce, and contracts. 2. All cases arising from strained relationship, such as matrimonial cases. 3. All cases where there is a need for continuation of a pre-existing relationship, such as dispute between neighbor and members of societies. 4. All cases relating to tortious liability, including motor accident claims. And 5. All consumer disputes. Efforts at streamlining mediation have been ongoing at various levels in the judiciary and the government. In 2005, the Supreme Court set up Mediation and Conciliation Project Committee (MCPC) to encourage court-referred mediation. The MCPC has since been working towards imparting training and generating awareness regarding the benefits of mediation. Earlier this year, the Supreme Court has also established a panel to draft a law governing mediation. Despite the absence of an umbrella mediation legislation, the Parliament has introduced clear-cut provisions for mediation in 4 legislation which govern different categories of disputes. This is a true recognition of the potential mediation holds in resolving these disputes without burdening an already overburdened court system. Under Section 12A of the Commercial Courts Act 2015, a suit which does not contemplate any urgent interim relief cannot be instituted unless the plaintiff exhausts the remedy of pre-institution mediation. The central government has authorized entities constituted under the Legal Services Authorities Act 1987 to conduct such mediations. The mediation procedure is required to be completed within a period of 3 months, which can be further extended by 2 months with the consent of the parties. Pursuant to this, the Commercial Courts Pre-Institution Mediation and Settlement Rules 2018, which lays down detailed procedures for such mediation along with fees applicable, has been notified. While the Consumer Protection Act 2019 also provides a framework for pre-litigation mediation, it does not make it mandatory. Under Section 37 of the Consumer Protection Act 2019, if it appears to the District Commission that there exist elements of a settlement, it may direct the parties to settle the dispute by mediation. As per Chapter 5 of the Act, these disputes are to be decided by the Consumer Mediation Cell, which is required to be attached to every district and state commission. Further, the draft Consumer Protection Mediation Rule 2019 have been released by the Department of Consumer Affairs for stakeholders' comments. The current draft prescribes the judge-referred court-annexed mediation model and recognizes voluntary The current draft prescribed the judge-referred court annex mediation model and recognizes voluntary mediation. Similarly, Section 442 of the Companies Act 2013 gives an option to the parties to proceedings before the central government, NCLT or NCLAT, to opt for mediation. It also empowers these fora to refer parties to mediation so moto. Even under the Family Codes Act 1984, a responsibility is placed on the courts to make efforts to resolve the dispute by settlement. Under Section 9, in every suit or proceedings, the court is required to assist and persuade the parties to arrive at a settlement by following procedure that they may deem fit. In fact, the statement of objects and reasons clearly states that establishment of the family court was with a view to promote conciliation in and secure speedy settlement of disputes relating to marriage and family affairs. For e-mediation to thrive, technology needs to act as a fourth party. That's what Mr. Batra had also mentioned, that apart from three parties, there is a fourth party, which is technology. That is, so the technology is to be embraced equally by all. The parties to the dispute, the advocates and the mediator. Not only do they need to have access to adequate technological equipment and internet, but more importantly, they need to trust the online process. This makes the job of the mediator all the more challenging as she bears the onus of making the parties comfortable with the new setup. The mediator needs to not only be skilled at mediation process, but also have a good grasp of the technology tools used for online mediation. While a greater shift to online mediation is a need of the hour, any procedural tweak to make mediation process more pervasive or encourage online mediation must be such that it does not compromise on the parties' right to access justice. A procedure that is made mandatory runs the risk of violating the rights unless it is done with great care, mindful of its repercussions. Therefore, before enacting a legislation that mandates pre-litigation mediation, it is absolutely essential that the system is ready to deliver in terms of supply of quality mediators and good mediation experience across all jurisdictions in the country. It has to be ensured that the procedure is fair and does not favor one section of the population over other. At this juncture, where the attempt is to boost mediation, it is important to tread carefully to create a robust system that generates confidence and lays the foundation for a future where mediation gains prominence as a preferred mechanism of dispute resolution mechanism, a recognition that it deserves for its effectiveness in a large number of civil disputes. MSMEs play a critical role in the global economy and should have access to flexible and effective tools and processes to help them resurface in times of financial distress. The World Bank Group estimates that 600 million jobs will be needed by 2030 to absorb the growing global workforce. Small and medium enterprises, SMEs, which are estimated to generate roughly 7 out of 10 jobs in emerging markets, are therefore a key layer of economy. These businesses, however, are more vulnerable to financial shocks and present a greater credit risk. The sector is the second largest employer in the country after agriculture, employing over 110 million people and contributing to over 29% of India's gross domestic product. Mediation has been seen to be extremely effective in resolving disputes pertaining to MSMEs, ensuring quicker disposal of disputes and more seamless functioning of businesses operations without much disruption. Online mediation is also especially suited to MSME disputes. In respect of family and matrimonial dispute, these often include other issues such as custody-related dispute and related civil disputes. There is a need to shift the focus from individual positions to interest-based position. as it is possible that in the matrimonial disputes, the interest of other family members are involved. Intervention is required to enable parties to understand how the process of mediation can provide mutually agreeable solution without damaging delicate familial relationships and ensuring the best possible outcome for everyone involved. Through mediation, a mediator can facilitate spaces for parties to communicate honestly their disagreements and expectations and gain perspectives through the eyes of neutral third party. Adversarial litigation can be avoided in several such instances, and mediation has truly enabled the best outcomes for parties. In respect of IPR related issues, traditional courts are often not fully competent due to lack of specific technical knowledge, and a skilled mediator possessing the exact technical knowledge and the ability to facilitate mutual agreement between parties can help avoid the long and expensive process of litigation, where the onus of proof and evidence is higher on both the parties. In patent infringement issues, for example, mediation can really be fruitful, keeping in mind that a patent is only granted for a limited period. Precious time taken up by litigation would harm business interests, and mediation can prove a useful way of resolving the disputes. ODR has also been commonly used by the National Internet Exchange of India, NIXI, which follows the World Intellectual Property Organization WIPO domain name dispute settlement mechanism. Platforms such as Presolve, 360 SAMA Center for Online Dispute Resolution, Resolve Disputes Online, etc., which provide for e-mediation or e-arbitration, are also appearing in the Indian dispute resolution market. Mediation gives the parties the flexibility to decide the manner and procedure to be followed to resolve the dispute, depending on the nature of the dispute and the relation between the parties. It also allows the parties to arrive at a tailor-made solution, minimizing an unfavorable impact. Parties have the autonomy to conduct a cost-benefit analysis before arriving at the most favorable solution. Additionally, unlike litigation where the documents once filed become public, mediation allows the parties to keep the documents and discussions undertaken during the mediation confidential. This is specifically relevant for the companies, as any adverse information about the company can fluctuate share prices of the company. It is worth mentioning here that various multinational corporation companies and partnership firms have also realized the above mentioned benefits of mediation, which has resulted in them introducing clauses for mandatory mediation in cases of any disputes or disagreement between the parties in their agreements. Sorry. I'm sorry. Considering the pandemic and the repercussion to follow, a shift in the dispute practice being driven by mediation would will be favorable to all parties involved. This shift would require us to be prepared, and hence it is imperative to ensure we obtain the requisite training and the skill set to be able to meet the changing demands. Participants in online mediation should understand how to use technology and be at ease using it. The video platform must be functional and confidential. It must have the option of having private meeting rooms in order to enable the mediator to have a private session with the party. Mr. Batra has done very well with his beautiful presentation. So how online mediation is conducted, how the confidentiality is maintained has already been said very in detail by Mr. Batra. So I won't go in detail. The platform should be able to provide good video and audio quality, regardless of there being multiple participants and lengthy session. The platform must also be secure in terms of protection of data. Then there should be a tech expert at hand to handle unexpected glitches or technical issues, and who could also provide a pre-mediation briefing to the participants on how to use the platform, how to mute, unmute oneself, or switch on or switch off, or use the whiteboard or the screen share. After all, the parties should be confident not only about the mediation process, but the technology being used. online mediation may also not really. So here I must mention that at some places where online mediation may not work, and that is where in certain situation where personal interaction by the mediator is required, say to convert negative emotions into a positive ones by using restorative justice practice, or where non-verbal and body languages cues from parties are crucial for the mediator to guide his or her approach. At that point of a time, there is a little vacuum in the online mediation, which is called the last minute negotiations or last minute breaking the impasse. That's where sometimes the online mediation is a little um, is a place where it really does not work sometimes. On the other hand, while online mediation has most of its advantages, it also bears some cautioning. Confidentiality can be compromised since hearings could be recorded. Service providers have to be vigilant, and rules will have to penalize participants for breach. At the heart of any policies or rules bolstering online mediation should be a commitment to access to justice and non-exclusion of those who cannot access the requisite platform. Thank you very much.
Thank you, ma'am, for your absolutely wonderful insights. I would now like to invite our chair for this session, Honorable Justice M.M. Sundaresh, who is also heading the Mediation Center for the Madras High Court, to please share his extensive knowledge and further enrich discussion on this topic. So,
Dr. Obviously, this co-chair, Senior Brigade himself, Mr. Sudhanshu Batra, Madam Lalit Mogi Bhatt, members of the organizing committee, members of the students organizing committee, faculty members, students, Dr. Astos Mishra, conference director, and last but not the least, Ankita was done a wonderful campaign here today. Very good evening to all of you. A wonderful presentation has been made by both distinguished speakers. I do not wish to repeat whatever they have said. Once Naziruddin Mullah was asked to address a gathering. He was elected speaker, but the audience wanted. He stood up and asked the audience, "Do you know what I am supposed to speak?" Although the entire audience said, "Yes, we know." Then he said, "If you already know what I am supposed to speak, there's no point in my speaking," and he left the podium. The next day, once again, he was asked to speak. He asked the very same. And this time, the audience, they became more smarter. They said, "We don't know." Then he said, "If I do not know what I am going to speak, what is the purpose that would be served by speaking to you?" Again. On the third occasion, the same thing happened. And this time, the audience became much more smarter. Half of them said, "We know what you are going to say." And the other half said, "We don't know what you are going to say." Address. And he said that those who know can tell the others. So, having called, I would like to only give an informal speech before this gathering, especially then Sri Batra and Madam Bhatt has spoken eloquently about the topic for discussion today. Let me start by saying this. Now, we all know law and justice, though they are different, they can travel on the same track. The problem would arise at times that the waters do not mix with each other. As Mr. Batra said already, we do have an adversarial system. having multiple. Are you able to listen? Am I audible?
Yes, sir, you are audible, but there is some connectivity issue, sir.
Audible. I think that's better. I think this is one mode of the online dispute resolution. It needs to cut off the speaker. Sometimes it's better to hear. Can I proceed then? May I proceed?
Yeah, sir, you can proceed.
In the multi-court system, the decision is made by the judge after hearing the arguments on both sides. We do have procedural and substantial law to decide this. As spoken by the distinguished speakers, there is a vast difference in mediation and a determination before the court. In a mediation, the dispute is settled, where in a court it is resolved. Now the parties are satisfied in an adjudicated process. Now the reason why I am telling this factor, which all of us know, is that the performance and functioning and the quality of the judicial system primarily depends upon the satisfaction of the litigant who is conceding. So only until and unless the mediation process is strengthened, then the dissatisfaction of one party in the litigation process would certainly continue. Madam has already also said, as spoken by Sri Batra, with respect to the time. The time is an important factor, especially when we deal with the litigation which we are addressing now. The commercial litigation in particular, the general litigation, the civil litigation in general. Now, Mr. Badal also spoke about the various types of litigation. He also got in a dispute between a landlord and tenant, or a dispute with respect to payment of money. Now, in this dispute, if the dispute takes 10 years ultimately, the party who ultimately loses would be the victim. This is a bad example for our system. Delay actually defeats justice. In a settlement process, the parties are in a win-win situation. After all, lawyers advocate the case of the parties and the judge decides. Now, all the three individuals, namely the parties who appear for the lawyers who appear for the parties, and the judge, but do not have a personal connection with the list. Therefore, the decision which arrives ultimately may not be palatable to the parties. Now, much has been said about the pendency. Let me tell you, when we speak of pendency, we can divide it into two different factors. The pendency of litigation which has been initiated and the pendency with respect to cases that have been initiated. In a healthy civil society, having a democratic setup with a robust judiciary, increase in civil litigation indicates confidence in the system. Now, if you take the population ratio vis-a-vis the civil litigation in a developed country like USA and even for example Singapore, we would find, we are surprised that the number of civil litigations are more, though they may not end up in the courts, meaning thereby they get resolved and settled at the initial level through mediation. This shows the confidence in the system. But I must honestly confess that what we are having today is inadequate flow of civil cases. Now, question is, now we have to introspect. Why does it happen? Why do we not having adequate civil cases? The reason is a litigant is not confident of approaching the court. This is what I am saying. Today, the confidence level of litigant over the court is diminishing. This is the hard reality. Therefore, the role of mediation comes in. If you have a robust mediation process, then the confidence would increase. It will make a civil litigant to approach the court more frequently than what is contemplating today. This process we need to strengthen. Now, I will give you an illustration because we are dealing with online dispute resolution, not only with the commercial litigation but also a civil litigation. After all, a commercial litigation, which just been dealt with the kitchen show by but is not a civil litigation. Though we carve out it as an exception, taking note of its importance with respect to procedural aspect and the time limit. And beginning some of the provisions as substantive. I don't propose to go into that in this category. But the fact remains, civil litigation, how do we enhance the process of mediation? Let me give an example. Now, in a district municipal court, a senior lawyer of repute was having substantial number of cases. Now, he decided to quit his practice and settle in abroad. He took up his gold bundles, then gave half of them to only first junior and the remaining half to the second junior. He told them, yes, now we have to make a living out of this. He left the country there. After some time, he called both his juniors and inquired about their performance. The first junior said, "Sir, I am keeping all the bundles with me and I am very happy because the matters are still pending. I keep on filing interlocutory applications or publications and I'm reasonably settled." The second young lawyer said, "Sir, I am almost in the process of finishing up all the cases. 50% of the cases I have settled, 50% I have completed." Then the lawyer was smiling. "All right, I'll call you after 2 years." The wife of the lawyer, she was very inquisitive and she was asking him, "Why are you laughing? I think it appears that your first junior is doing well as in the second one." He was smiling. "When you please wait and see." Then after a decade, he came back to India and asked for the juniors. He found the first one last 50% of these cases, while not adding up to the bundles given by his senior, while the second one became a senior lawyer of repute, adding more cases. Then he asked, then he was smiling and he told his wife, "This is the reason why I was smiling the other day." And before his wife, he asked the second junior, "How did you do that?" Then he said, "Sir, all those litigants who came before me, they were very satisfied because I resolved the dispute by mediation with half of with the others. I gave him the result. Some of the cases I dismissed, I lost it, so some of the cases I won. They were very happy that the dispute the disputes were over one way or another. Now, he asked me first here, what happened? And he was particularly, you are asking about one case he was given to him. And this case is with reference to a dispute between two farmers for a fence. Now, the question is, to whom does the fence belong to? The value of the fence was open to trees. It was a more of a prestige dispute between them. It went to the court. The defendant lost the case before the court of first instance, and the appellate court, with the second appeal having been confirmed. The lawyer told him that these three judges, both at the district level and the high court level, they are not able to understand the question of law raised. Let us put up a case before the Supreme Court. Now, he said, all right. Then he sent the client to the Supreme Court lawyer with the cover. He go and meet so and so. He met the counsel, and before doing so, out of inquisitiveness, he opened a cover. Upon opening, he found something, a letter having been written by the High Court lawyer to the Supreme Court lawyer. Now, in that letter, he has only said this. This is a holy cow. You can milk it as much as you want. Now, after reading this, the litigant, though he met the Supreme Court lawyer, told him that I am not going to fight the case, and then he returned. He went to the other lawyer, the other junior of the city council, who divided the cases between his two juniors, and told him. Then he asked him, all right, you have believed in the village headman. He said yes. What about the other person? He also believes in him. He's a good man. Then he said, all right, now I am referring the case to the village headman. Both of you want talking. Both of them talk to the village headman and resolve the dispute. Then the litigant came back to the lawyer and told him, I am very happy with your performance. The news spread like a forest fire, and as a result, the other lawyer who helped in resolve the dispute got more praise. Now, this is the ground reality which we are facing now. Now, we are faced with the same situation when it comes to the online education also. Now, what would be the difference between an online education and online resolution and a mediation in person? There are a lot of differences. As a head of the committee, we have addressed this issue by calling the master trainers to train the other mediators. There are multiple issues involved in this process. The first one is, as the distinguished speakers said, the question of connecting the mediator with the parties. Now, how do the mediator address? Okay, even when the same problem even I had as a judge while addressing the lawyers in hearing matters, because we are not used to this. But this connection would evolve by taking into consideration of small and little factors, like the way in which we address the parties. Now we need to develop a relationship at the initial stage, earn their confidence, speak to them nicely, and do not expect anything in return. Now, today morning, let me also bring a small thing which I was reading the newspaper today morning. There was a children's magazine published every Friday. So I was reading a small story. It's imaginary talk between a key and a hammer. A man, after locking his room, lost his key. Inadvertently, he has kept it somewhere else. He was not able to find it out. So he was in a dire need of opening the room. After making initial search, he went to the he took up his hammer and started breaking the lock. It was not opening. Then, incidentally, his wife came and she was giving him the key, telling that you have forgotten the key, you kept it there. Then he used the key and opened it up. This is the story. Then, the imaginary discussion was between the hammer and the key. Now, the hammer, which was proud of his muscle power, was a bit confused. He was asking the key, why did not the lock come up when I was using all my force and power? Then the back came the reply to the key. You are hitting the lock on his head, but I am opening his heart. Now this is exactly what that is required. More so for an online mediation. Getting connected with the parties will be more important. Now, how do we get connected? By not only listening to them, having constant chatting, understanding them, what do they believe they want, and what will be the consequence if the league is given, what the other side requires. Now, sometimes the online mediation would give a better result. Why I am saying is this. Now, this is again Mr. Bhattacharya and Madam was talking about this. Now, how the mediator present himself while dealing with the parties? The first one is his way of presentation, as I have said earlier. The second one is even his or demeanor. How does he present himself? Now, how does he present himself and what is the ambience? Ambience, in my view, would be more important. Now, if all of us, if we go to a new place, our first natural instinct will be to look around. In a new place, some of us will be uncomfortable. For example, I will be a little bit uncomfortable if I go to a 5-star hotel, which I am not used to. Now, because when you enter into the 5-star hotel, you are conscious of your own dressing, your own speech, your own manners. So, because these things will take substantial part of your preparation than the actual discussion. So this will be the position with any other place. Now in an online mediation, and we have seen now. We have heard the co-chair, Madam Bhattacharya and Madam Bhatt. Now, Madam Bhatt, I have observed that she in her room, she is beautifully decorated with wonderful wallpapers. I mean, pictures on the wall. So this is something we can pick it up and then interact with the parties, then making them feel more comfortable, and so that they can compare in the mediator. Whether we like it or not, mediation, online mediation process is going to continue. Mr. Bhattacharya is absolutely right. As a community, I think the legal community is always reflected to change. right from the resistance to the change in enactments and with the civil procedure code. We are very much elected. But having said that, now this technological development is an innovation that we need to adopt. And if we want to survive, we need to adopt. Otherwise, we be relegated to history. So this is this online mediation. In my personal experience, I find not only the commercial litigation, even the civil disputes are getting resolved. Now, some doubt has been expressed with respect to the technological know-how and understanding of the technology, which is correct. But I think we can address this issue by asking the mediation centers to look into this, and by opening the legal service authority, by asking the parties to come to the legal service authority with the help of the technocrats and experts. They can facilitate us. Now a party can have the comfort now. Sitting at home, he or she can interact. And most importantly, I find it takes care of distance, travel and distance. Now we don't need to worry about this. We take care of this aspect. Consequently, the time barrier also goes. For example, a party in an international arbitration, a commercial arbitration, a party may be in a different country, one party, the other one may be in a country. At different parts, at a particular agreeable time, we can have it. So time is not a factor apart from travel. So I think looking from different perspective, we can safely say it is not only helpful to the litigant but also to the lawyers. The more civil litigation we generate, it is better for the legal community. The better reputation we derive, it is better for the judiciary. With these few words, I thank the organizers for giving me this opportunity to express my views before this August. Thank you very much.
Thank you, Your Lordship. It's an absolute honor to have you with us today. With this, we reach towards the end of the session. The discussions by the panelists truly have been deeply rewarding and informative. To present the vote of thanks, I would again invite Professor Dr. Vageshwari Deswal, ma'am. Ma'am.
Yes, Ankita. That was an awesome session. It is my prerogative to propose a vote of thanks to our esteemed guests. Our guest of honor, Shri Sudhanshu Batra, rightly remarked that future of ODR and virtual mediation is bright, and we need to train mediators and trainers at all levels, and there is an urgent requirement to frame appropriate curriculum that should be consistently followed across all law schools. Thank you, sir, for your valuable inputs. It was a wonderful presentation. And you've raised extremely pertinent points regarding utility of online mediation in contemporary times. Ms. Lalit Mohini Bhatt, she highlighted the need to first decide cautiously what matters can be resolved via mediation. It is to be preferred wherever possible, as it saves unnecessary travel, multiple court visits, while managing things from the comfort of the home, and especially during these times of COVID. Thank you, Mohini ji, for the delightful discourse on significance of online mediation. Thanks are due to Honorable Mr. Justice Sundaresh for his valuable inputs related to resolution of pendency. I take this opportunity to convey my deepest regards and heartful thanks to you, sir, for sharing your views on this subject in a very simple manner with practical examples. I am sure that all our participants have benefited immensely from your presentation and also from the presentations made by our other two speakers for the day. I would be failing in my duty if I do not acknowledge the initiative taken by Dr. Ashutosh Mishra, Assistant Professor at Law Faculty, under the patronage of Professor Mahavir Singh, Professor in Charge, Law Center 2, and Professor Joshi, the Honorable Vice Chancellor of Delhi University, for organizing this international conference on a very relevant and important theme, and taking pains to invite esteemed speakers from all across the globe to enrich us with their views. Dr. Ashutosh Mishra has been very ably supported in this endeavor by Dr. Ashutosh Acharya and Dr. Ajay Sunagane. Thanks to the team, thanks to all the speakers and participants. Stay safe.
Thank you, ma'am. I again thank everyone for being with us today. I'm sure it has been a great learning experience for you all. I request all the participants to kindly fill the feedback form that is provided in the chat box. With this, I end the meeting. Wish you all a great day ahead. Stay safe.